of the North Carolina Utilities Commission. With me this morning are Chair Karen M. Kemmerite, Commissioners Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, and Tommy Tucker. I now call for hearing on docket number W-1334 sub 8, the public staff's complaint and show cause proceeding against North Carolina Water and Sewer LLC for unauthorized activities in multiple service areas. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. On June 28th, 2024, the public staff filed a complaint and show cause proceeding against North Carolina Water and Sewer LLC, or NCWS, for unauthorized activities in multiple service areas. On July 19th, 2024, NCWS filed a response to the public staff's complaint and an offer of satisfaction. On August 2nd, 2024, the public staff filed a letter renewing its request that the Commission schedule a hearing in this matter. On September 6, 2024, the Commission entered an order scheduling hearing, requiring filing, and requiring information to be provided by the public staff. Buckhorn 7 LLC petitioned to and has been allowed to intervene in this proceeding. On September 13th, 2024, NCWS filed a response as required by the Commission's September 6th, 2024 order, including some confidential exhibits. Thereafter, on September 27th, 2024, NCWS filed a supplemental response. On October 24th, 2024, the Commission issued an order continuing hearing and establishing procedural schedule, which, among other things, rescheduled the hearing to begin at 10 a.m. on February 11th, 2025. On November 25th, 2024, the Commission entered an order modifying the procedural schedule. On January 2nd, 2025, Buckhorn moved the Commission for a 3-day extension of time for interveners and the public staff to submit direct testimony through and until January 9, 2025. The motion did not seek an extension of time for NCWS's direct testimony. Buckhorn's motion was granted by the Commission. On January 9, 2025, the public staff filed the direct testimony of Evan Hauser. Am I pronouncing Mr. Hauser's name right? Buckhorn did not file any testimony in the docket. On January 17, 2025, the Commission issued an order extending the deadline for NCWS and required NCWS to file direct testimony on or before January 23, 2025. On January 23, 2025, NCWS filed the direct testimony and exhibits of Michael Myers, Charles Donnell, and Thomas Hester Jr. On February 10th, 2025, the public staff filed a motion to delay the hearing. Consequently, the Commission issued the order postponing the hearing. On February 11th, 2025, the public staff and NCWS filed a joint motion to hold the matter in abeyance and accept and approve the agreement and stipulation of settlement with the agreement and stipulation attached as Exhibit A. In addition, Buckhorn filed a letter notifying the Commission that Buckhorn resolved its dispute with NCWS, did not intend to participate in any hearing in this docket, and did not object to the joint motion of the agreement and stipulation of the settlement. On February 21, 2025, the Commission issued an order rescheduling the hearing to today. On March 14, 2025, NCWS filed a motion to excuse witness Hester from appearing at the hearing in this matter and to allow witness Hester's pre-filed testimony to be entered into evidence at the appropriate time. On March 17, 2025, yesterday, the Commission issued an order excusing witness Hester's appearance. In addition, on March 17, 2025, NCWS filed a customer service report for January and February 2025 with a confidential Exhibit A. That brings us to today. I now call upon counsel for the parties to introduce themselves for purpose of the record, beginning with public staff.
Ms. Rita Coxton, appearing on behalf of the public.
Thank you, Ms. Coxton.
Chair Levitas, I'm Sam Irvin IV of counsel with Brooks Pierce. I'm appearing with Amanda Hawkins, who is a party in the firm. We represent North Carolina Water and Sewer.
Morning. Are there any preliminary matters that need to be addressed at this time?
No, sir.
At what point do you want to deal with admission of Mr. Hester's testimony?
I had planned, since I was understood that we needed to go first, I was simply going to move to admit the stipulation into evidence and to move the admission of Mr. Hester's testimony.
Okay, that'll be fine. But I believe we're beginning with the public staff since it's their complaint. Was that your understanding, or?
We inquired of the commission staff
Okay.
as to who went first, and we were informed that it was North Carolina Water and Sewer. And if thinking about how to do the hearing today, that's what Ms. Coxon and I had understood we were supposed to do. So
Okay, well, fair enough. Well, let's proceed in that fashion at this time, Mr. Irvin.
Right, I will formally move first that the stipulation between North Carolina Water and Sewer and the public staff be admitted into evidence.
Seeing no objection, admitted.
Secondly, to answer the question we started this colloquy with, I would move that the testimony of Mr. Hester be admitted into evidence and copied into the record as if given orally from the stand in accordance with the commission's order of yesterday.
Without objection, the pre-filed testimony of Thomas S. Hester, consisting of 6 pages filed on January 23rd, 2025, will be copied into the record as if given orally from the stand.
Thank you. At this point, we would call, and again, my understanding from our communications with the commission staff is that calling Mr. Myers and Mr. Donnell as a panel would be acceptable. So I would call the two of them at this point and ask them to come up and take a seat at the witness stand.
Thank you. Okay, let's swear the witnesses. Could you place your left hand on the Bible and raise your right hand? Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may proceed.
Thank you, Chair Levitas. First of all, Mr. Myers, would you state your name and business address for the record, please?
Full name is Michael John Myers. Business address is 4700 Homewood Court, Suite 108, Raleigh, North Carolina.
And did you cause to be pre-filed in this proceeding direct testimony consisting of 40 pages with 8 exhibits identified as MM1 through MM8? You cause that to be pre-filed?
I did.
Do you have any corrections to your testimony that you would like to make at this time?
Yes, sir.
If you would proceed to do so.
Okay. At page 2, line 16, replace the comma after Carolina with a period and delete as is now known as Fort Liberty. At page 15, line 19, W-1334 sub 0 should be W-1334 sub 8. At page 17, line 15, November should be October. And at page 17, line 16, the first reference to May 2023 should be October 2022.
Do you have any brief updates to your testimony relating to 2 of the systems that are discussed in that testimony?
Can I ask a clarifying question? Which?
With respect to Plain Ridge and Pleasant Union,
Yes, sir.
would you update your testimony with respect to those 2 subdivisions?
We have entered into agreements with the developers on both of those systems to terminate those 2 agreements between us and the developers.
If I ask you the questions that were contained in your pre-filed testimony as modified and supplemented. If we ask those questions today, would your answers be the same?
They would.
Chair Levitas, I would move that the pre-filed testimony of Mr. Myers as corrected be admitted into evidence as if given orally from the stand, and that his exhibits be identified as pre-marked.
Without objection, the pre-filed direct testimony of Michael Myers, consisting of 40 pages, filed on January 23rd, 2025, will be copied into the record as if given orally from the stand, and the 8 exhibits will be pre-marked for identification.
Right.
And Mr. Myers, if you would mind just speaking into the microphone a little more, so we're having a little trouble hearing you.
Okay, is this better?
That's better.
Thanks.
Right. And Mr. Donnell, did you cause to be pre-filed in this proceeding direct testimony consisting of 8 pages and 2 exhibits identified as CD1 and CD2?
Yes.
Do you have any corrections to your testimony?
No.
If I ask you the questions that were contained in your pre-filed testimony today, would your answers be the same?
Yes.
Chair Levitas, I would move that the pre-filed testimony of Mr. Donnell be admitted, be copied into the record as if given orally from the stand, and his exhibits be identified as pre-marked.
Seeing no objection, the direct pre-filed testimony of Chuck Donald, consisting of 8 pages, filed on January 23rd, 2025, will be copied into the records if given orally from the stand, and the 2 exhibits will be pre-marked for identification. Thank you.
At this point, the witnesses or the panel is available for cross-examination.
Any cross-examination?
No cross-examination by the public staff.
All right, then we'll turn to questions from the commission, and I will start. Most of these questions, I think, are for you, directed to you, Mr. Myers, but Mr. Donald, feel free to participate in the responses if that would be helpful or appropriate. Let me just ask one question right at the outset with regard to the correction to your testimony, Mr. Myers. And at that moment, I was having a little trouble hearing you. Did you say that you have terminated the agreements with 2 of the developers so that my inference was that meant that NCWS would no longer be providing service to those developments, but maybe I misunderstood you.
That is correct. We've terminated with 2 of the developers we were working with, and will no longer be seeking authority to provide service in those areas.
Which 2 are those?
Lane Ridge and Pleasant Union.
And I believe that in the Pleasant Union docket 1334 sub 7 that yesterday you withdrew a CPCN application. Is that connected with the change in circumstances you just described?
Yes, sir.
Okay, thank you for that. And I also note that I believe it was yesterday you filed the first of the monthly reports required under the stipulation and settlement with respect to customer complaints. Is that correct?
That is correct.
Thank you. Do you anticipate any problem in continuing to file those complaints in a timely, of those reports in a timely fashion?
We do not.
Good, thank you. Could you talk just generally about the steps, that's obviously one of them, but the steps that you've undertaken to date to implement the stipulation?
If I can, I've got some notes on that to help me through that, if I can just kind of.
Yes, absolutely.
Okay. So yeah, on March 7th, North Carolina Water and Sewer submitted to the public staff for its review a draft CPCN application for Huffington, a draft CPCN applications for Buckhorn and Norwood. On February 26th, North Carolina Water and Sewer submitted to the public staff a draft agreement between NCWS and EnviroLink. NCWS is continuing to work on that agreement, and we anticipate being ready to file by March 31st. On February 27th, North Carolina Water and Sewer met with public staff to discuss developments in which NCWS is negotiating to provide service and water quality issues at Buckhorn and Huffington Manor, the status of NCWS's efforts to install a generator at Buckhorn Creek, status of NCWS's efforts to install iron and manganese filters at a system called Huffington Manor. We discussed clarifying the identity of the entity that provides water service in Buckhorn, Huffington, and Norwood, and EnviroLink's roles. We submitted a calculation of customer refunds that NCWS has agreed to make, and NCWS has continued to comply with public staff's request for information. On March 13th, at the February 27 meeting, NCWS agreed to provide the proposed refund calculations for Norwood. NCWS provided its proposed calculations to public staff on March 13th. On March 13th, provided information to the public staff's request about how customer service phone tree works, the percentage of customers who have opted in to receive phone and email communications in each of the subdivisions, whether there is a link for customers to pay their bill through EnviroLink's website. March 17th, we provided the template for communications for system outages in response to a public staff request. And then regarding water service and quality, at the February 17th meeting, NCWS discussed efforts to clarify the identity of water and sewer provider. NCWS submitted proposed reintroduction letter to the customers for public staff's review and comments. NCWS has solicited and received engineering and construction proposals from Water Purification Consultants Incorporated for the installation of the filtration system at Huffington Manor and the installation of the generator at Buckhorn. North Carolina submitted and filed the customer service report and its work order logs for January and February 2025. As part of that report, NCWS reported that it had only received one customer complaint on January 31st, 2025 concerning discolored water due to some flushing activities that were going on at that time.
Thank you. Thank you very much for that detailed report. I want to start by focusing on one element that you referred to, which is the draft contract between NCWS and EnviroLink. Now, as I understand it, EnviroLink has provided contract services to many water and sewer utilities over the years. Is that correct?
That is correct.
Is it typical, or in fact, is there any precedent for your providing such services to a utility without having a written contract in place?
I would say it's certainly unusual. Have there been situations where we have, based on a verbal agreement? Yes, but few and far between.
Yeah. So what's the explanation for why the relationship was undertaken in this case without a contract being in place in advance?
I would say EnviroLink has not been compensated. While it's providing service, it has not been compensated by North Carolina Water and Sewer Services. So while EnviroLink has been providing services there, it has not been compensated. So it was done in anticipation of a contract.
Well, I guess that leads me to another question, which is what was the business reason or rationale for a for-profit company entering into a relationship with another entity for which it wasn't going to be compensated?
I think the expectation was we would be compensated eventually, but that it was done because those systems were commissioned and began providing service, and that needed somebody to provide service, and North Carolina Water and Sewer did not have the staff at that point in time to provide the services.
Mm-hmm. Is it, as someone who's worked in the industry for a long time, is it your best professional judgment that it's best practice, or is it a good practice to have a situation like this where there's no contract in place between the parties?
It is not.
I'm glad we agree on that. So has EnviroLink now begun charging for those services?
We have not.
So that will not occur until the contract is in place and has been approved um, by the public staff and the commission.
That is correct.
Thank you. And where do you stand in, I thought I saw on the record that there was a draft contract that had been developed some time ago, but I know the stipulation provides a new timetable for the development of that contract. Where do you stand in your conversations with public staff on that contract development? I think it's due at the end of the month. Is that right?
Yeah, we have submitted a draft to public staff. I think here, subject to check within the last couple of days, that is still under review by public staff.
Okay. And you don't see any reason that you won't be able to make the March 31 deadline to get that completed?
I do not. No.
Thank you. Just kind of thinking more broadly beyond the contract issue. I know in your testimony, I could pull up the page, but you mentioned that it was not unusual for there to be contract providers performing various services for public utilities. Is that correct?
I'm sorry, can you repeat the question?
Let me just help you by finding the page in your testimony that I'm referring to. I think it's page 30. 1 second. Page 26, lines 7 through 12. And there was, issues raised about potential confusion between the two entities, NCWS and EnviroLink. And you stated in your testimony, it's not uncommon for water utilities to use an operator for administrative and customer service functions. Do you see that in your testimony?
I do.
My question is, in your experience, in your opinion, is it common for there to be a relationship between a service provider and a public utility in which both entities have common ownership? Is that something you've done before?
I don't know that I'd have an opinion on that as to how common that is.
Well, in your personal experience, have you, as a contractor, as a principal in EnviroLink, have you ever previously provided contract services to a public utility in which you also had an ownership interest?
Yes, sir.
Where was that?
Currituck Water and Sewer.
Have you seen opportunities for confusion or conflicts of interest where you have those types of affiliated relationships under common ownership?
Yes, certainly there is the potential for that. And like in the case of Currituck Water and Sewer, in those negotiations, early on, I represented the EnviroLink side, but did not participate from the Currituck side. And since then, I've recused myself from negotiating on either party's side. So.
Okay, I was going to ask you about what steps you take or think need to be taken to avoid conflict of interest or appearances of conflict of interest. It sounds like that's one of them, is for you as the joint owner not to participate.
That is correct.
Oh, good. But in this case, you did initially participate in those negotiations on behalf of one of the entities or both of the entities?
In the case of North Carolina Water and Sewer, Mr. Ken Raber represented North Carolina Water and Sewer, and then on the EnviroLink side, John Greer represented EnviroLink.
And who are they?
Mr. Raber is president of North Carolina Water and Sewer, and John Greer is the CFO for EnviroLink.
Okay. How many employees does North Carolina Water and Sewer have?
Mr. Raber is the only employee.
So is it fair to say that it does not have the ability to perform the sort of duties and responsibilities and services of a public utility except through contract operators such as EnviroLink?
Yeah, those services would have to be contracted out.
Thank you. I wasn't, I've been a party to the Currituck Water and Sewer proceeding, but could you describe how the representation of the two parties was handled in that case?
Yeah, so there are two owners in Currituck Water and Sewer. One is Clear Current, and the other one is Longleaf. In that case, Mr. Greer represented EnviroLink's interest, and on the Clear Current Longleaf side, those interests were represented by Clear Current.
And what was your role?
I did not participate in those discussions.
Now, when you're not currently, EnviroLink is not currently charging NCWS for its services, correct?
That is correct.
And when is your intention to begin charging services? Is that after the contract's been approved and is in place?
As I understand it, step one is for the commission to approve the agreement between NCWS and EnviroLink. And then after that agreement is approved, then we can begin charging for services.
Okay. I think you said you've already drafted, you have a draft of a contract that you've shared with the public staff. Is that correct?
That is correct.
And does that contract contain provisions that are designed to avoid conflict of interest and ensure that the parties have an arm's length relationship?
I don't recall there being any provisions in that agreement to address that specific issue. So,
Yeah.
but certainly I'm willing to, amenable to putting those types of provisions in there.
Okay, thank you. So shifting gears a little bit, I believe that, let me again turn to your testimony. So obviously the charging of customers for services in the absence of CPC, and you've acknowledged, is not in compliance with the law and is in fact a serious violation, correct?
Yes, sir.
I'm trying to, I know you offered some explanation in your testimony and an apology. I'm trying to understand a little bit more about how this could have occurred. And my first question is, what is your title or business relationship with NCWS?
I'm the manager.
Manager.
It's an LLC, and so I'm the manager.
And is it your testimony that over the course of what seems like it varied in the different cases, but anywhere from a year or more, that you literally had no knowledge that revenues were coming into companies that you managed through water fees?
That's correct. I had, at that point in time, I was being stretched pretty thin by several matters that were not, and I delegated NCWS to Mr. Raber and other staff members and was not actively involved in a lot of the activities going on within NCWS. And so then, yeah, I became aware, once I became aware of what was going on, actually stopped those practices, even prior to the public staff's complaints.
Okay. So you literally were not aware of or paying attention to the profit and loss statement or any kind of financial records that would indicate whether money was coming in or going out with the company that you managed?
Yeah, I had delegated all of that down to other members just because a couple of out-of-state things that were required my attention, and then there was some other matters that required significant portions of my time.
And you referred to Mr. Raper, is that his name?
Raber, R-A-B-E-R.
Raber. And is that the person you're referring to in your testimony on page 18 at lines 9 and thereafter? You say, I've come to learn that this same person did not follow up on the applications. It failed also, I'm sorry, also allowed the provision of service for compensation to begin. Is that Mr. Raber you're referring to there?
Can you reference the?
Yeah, sorry, it's page 18. It's a sentence that begins at line 9 and continues to line 12. And there would been, in your testimony, there had been a previous discussion of problems associated with the timing of the filing of the applications. And you had previously said that there was an employee who didn't understand what was required in that case. Now we're talking about the problem of charging fees without being certificated. And you indicate it's the same person who was responsible, at least directly, for the problem. And I was just asking if that's Mr. Raber or someone else you're referring
It
to.
was not Mr. Raber. It was the CFO at EnviroLink at the time.
And what's that person's name?
His name is Aaron Gold.
Is he still employed with EnviroLink?
He is not.
So that, of course, leads us to a question of how it came to be in the case of a regulated public utility that you have. He was CFO,
Yes, sir.
and had he not been informed or instructed as to the requirement or the prohibition of charging for water service without a CPCN?
So reportedly, he had had some guidance that as long as he had filed the applications, that it was okay. And so that was the explanation I had received after we had inquired and found out about it and inquired.
Well, I appreciate your accepting responsibility as the big cheese. But has this led you to conclude that there may be some problems with your training and education of employees as to regulatory requirements?
I think certainly anytime you have those types of failures, you start asking yourself, is it a personnel issue? Is it a process issue? And so, yeah, I think, we identified that there was both the process issues and personnel issues that needed to be addressed. And we've invested pretty significantly in both upgrading the personnel within the company and upgrading the processes and systems and controls within there to make sure that this doesn't happen again.
Good. Specifically including being sure that all relevant employees are informed of this very important regulatory prohibition.
That is correct. Yes, sir.
Thank you. Let me turn now to the customer refunds that are part of the stipulation. Have those refunds been made?
They have not. We have submitted the calculations to public staff for their review. We wanted to make sure that they agreed with how we were calculating things before we made those refunds. And as soon as public staff and we agree that, yes, this is the way the calculation should be done, we're prepared to make those refunds.
Good, thank you. I don't know if you are familiar with Mr. Hauser's testimony about some of the, I'm turning now to the performance problems, and I believe it's page 30 of Mr. Hauser's testimony. Let me check. Yes, page 30 at line 6. And this is an issue that has come up in a couple of recent proceedings here since I've been here about how water and wastewater systems get into trouble. And I think there's been evidence in other proceedings that there are problems that occur on the front end that perhaps could be addressed and avoid some of the problems that we deal with on the back end. And Mr. Hauser suggests that with respect to the problems, and I guess he's particularly referring to the filtration and the backup generator, that those are matters that you might have addressed with the developers and taken advantage of warranties that were in place in order to get those addressed rather than having to deal with them after the fact and having to respond to all the complaints that have resulted from those equipment problems. What thoughts do you have about that? And do you think there was a missed opportunity in trying to hold the developers accountable?
Well, I know, and I may refer to Chuck here because I think he maybe has better information than I have, but there were some warranty issues that we did address between the engineer, and in the case of Buckhorn, with the engineer and the developer early on.
Yeah, excuse me, there was a leak out at the Buckhorn well site, the primary well site. And there was an issue, one of the contractors who was putting in the water system was fired, and another contractor was hired to replace him. And so neither, the person that was fired didn't have a warranty, and the person that came in to replace him said that where the leak wasn't his problem. So the engineer, the design engineer, actually paid for the leak to be fixed.
But in the case of some of the other issues related to the power, I think the power that at Buckhorn specifically, yeah, the developer, certainly we brought the warranty issue up to the developer who refused to provide a warranty in that case. And so we were left with the choice of, do we pursue legal remedies or do we just fix the issue? And the decision was made to just, address the issue.
Just returning for a moment to the EnviroLink NCWS relationship, and I know some of this is in the testimony, but if you could just review for us the ownership structure. I know you and your family and family trusts have ownership positions, I think, in both companies. But just want to be sure the commission fully understands those relationships and structures. So could you walk us through that, please?
So in the case of EnviroLink, I own EnviroLink. I'm an owner of EnviroLink. In the case
That's,
of,
excuse me, that's 100%.
yes, that is 100%. In the case of North Carolina Water and Sewer, that is owned by a company called Longleaf, but ultimately rolls up to a family trust, of which I'm one of the trustees with my wife.
So NCWS, excuse me, 100% owned by Longleaf, which in turn is 100% owned by the family trust.
That is correct.
Do the two entities have the same business address?
They do.
And do they share other equipment? I mean, you mentioned there's only one employee of NCWS. Is he also an employee of EnviroLink?
He is no longer. He started out when the relationship with him started back in, I believe it was 2012. He was working with EnviroLink, and then we have shifted him over to, I will say, Longleaf / North Carolina Water and Sewer exclusively now.
Okay. Are there any steps that you take to establish, maintain, or preserve independence between the two entities?
I think, we talked about in terms of the potential conflicts of interest. We certainly have, appointed Ken Raber. Part of the reason we did that was so that he, without having responsibilities in EnviroLink, was so that he was not conflicted in any way. That's the only things that come to mind at this point in time.
Yeah. Well, I think I'll stop there and let some of my colleagues ask a few questions, starting with Chair Kemmerite. Thank you, Mr. Myers.
Good morning, Mr. Myers. I have a number of questions, and I think I'm going to start with following up on Commissioner Levitis's questions. First of all, we talked about the report, the customer service report for January and February 2025 that was filed on March 17th of 2025, which I believe is yesterday. Is that correct?
Yes, ma'am.
Okay. And when I look at the stipulation, it states that this is on page 9 of the stipulation, section 2.5. And it states that the first report shall be due on March the 5th of 2025 and shall include all complaints received between January 1, 2025 and February 28, 2025. Can you help the commission understand? We've just gotten the stipulation agreed to, we're part of this proceeding. Why was the report filed late? It seems from the commission's perspective, this is critical to file, to comply with the stipulation.
Not trying to make excuses, but the two individuals responsible for that, one had a personal tragedy in his life, and the other one was ill and did not get the report out timely. So yeah, that's not, again, not trying to make excuses, but that's why it was not filed timely.
Well, Mr. Myers, would you agree that you are ultimately responsible for
Agree.
ensuring that the stipulation is complied with and that the report was filed timely?
Agree.
Then you talked about, I was trying to make notes about the meetings that you've had thus far with the public staff, and I was not able to write the dates of the meetings down quickly enough, but I heard February 27th, I believe, or can you tell the commission the dates of the meetings that you've had with the public staff?
February 27th, I believe, is when we met with the public staff.
Okay, so there's been one meeting?
Yes.
Okay. And then in the stipulation on page 10, and this is section 2, 6, it states that NCWS commits to having responsible managerial personnel in attendance at each of the meetings. Can you tell the commission who was, on behalf of NCWS, who is present at that meeting?
Subject to checking, myself, John Greer, Ken Raber, Chuck Donnell.
And who is John Greer?
He's EnviroLink CFO.
CFO. And you answered some, so I'm going to move to something else that you testified about, stating that it would be unusual for there to be a situation in which a public utility, well, let me back up. You talked about ownership interests from EnviroLink and North Carolina Water and Sewer. And are you in agreement that EnviroLink and North Carolina Water and Sewer are affiliated companies? Do you disagree with that position or that statement?
So legal counsel, I think, has advised me that yes, there is an argument that they are not affiliated. However, we've voluntarily agreed to abide by the affiliation provisions in the commission's rules.
Okay, well, Mr. Myers, you essentially own 100% of both EnviroLink and North Carolina Water and Sewer. Am I missing the ownership structure?
No, ma'am.
Okay. You stated that it might be unusual for, and this will be my words, affiliated companies, because I know that you're not agreeing that they are affiliated companies at this point, but companies in which the owners own essentially 100% interest of both companies, entering into having a contractual relationship that has not been reduced to writing in a contract. You say that that is somewhat unusual. And I think your testimony, based upon Commissioner Levitis's questions, was that you didn't view it as particularly problematic because EnviroLink was not being compensated. Is that my understanding of your testimony?
Yeah, I think, yeah, it's my understanding that in terms of, having the agreement approved, that agreement has to be approved before EnviroLink can receive compensation for services.
But what I'd like to understand, though, is that you testified you were anticipating that EnviroLink would be compensated for the services that it provided. So the services it has been providing to the different subdivisions where wastewater service is being provided. Were you intending that EnviroLink would only be compensated after the agreement had been approved by the commission? And I'm not talking about now, I'm talking about during the period when EnviroLink was providing service.
I think I know your question. I just want to make sure I'm clear. Is in essence, you're from the period of time when EnviroLink first provided services to NCWS up until when the commission, may or may not approve the agreement. Does EnviroLink intend to kind of recoup its cost from that period of time? And
correct.
And the answer would be no.
Was that the intention or understanding of EnviroLink before the complaint was filed by the public staff?
It was.
Okay, so you were never intending to receive compensation for EnviroLink during the period in which you were providing service?
That is correct.
And how was EnviroLink to be compensated? I mean, it seems like a very unusual arrangement in which two affiliated companies, or my words, two affiliated companies, and one is going to be working for free. I mean, it's difficult for the commission to understand how this situation came about and what sort of business structure was being undertaken. Can you help the commission understand?
Yeah, certainly I don't think we anticipated it taking this amount of time, is one thing I would say. And then secondly, EnviroLink, I think, is looking at it from a longer, perspective of saying, hey, look, once we get approval, then we'll be able to provide operational support services moving forward.
The compensation was going to North Carolina Water and Sewer until the public staff filed his complaint. Is that correct?
Well, actually, we stopped billing prior to the complaint by the public staff.
Yeah, and that's something else I want to make clear. Did you stop, when you stopped billing, was it in response to concern of the public staff? Or did you stop billing before the public staff approached North Carolina Water and Sewer and said that there's a problem? You're billing customers without CPCNs, or did you do that before the public staff approached you?
And I can't remember the exact timing of this, but I would, subject to check, I would say it was before the public staff approached us, but it happened the timing was very close together.
Okay. Well, I'll ask the public staff because I think that that's an important detail. So if you have an opportunity to think about it and look back through your notes during questioning, because I do want to know whether North Carolina Water and Sewer stopped billing customers before it was brought to your attention by the public staff that you were billing without CPCNs.
Okay.
And one thing I do want to get cleared up for the record, because it's possible that that my understanding is not correct, but I did not participate in the Currituck Water and Sewer proceeding. But was my understanding that in the negotiations, the testimony that you provided in the the Currituck Water and Sewer proceeding, that your testimony was that you participated in the negotiations between EnviroLink and Currituck Water and Sewer on behalf of EnviroLink? We have a transcript, so I can go back and look through it, but I want to make sure that the record is clear in this proceeding. Is my understanding incorrect about that?
So I think, as I testified here just a few minutes ago, the initial contract between Currituck Water and Sewer and EnviroLink back in, I think it was 2021, I did participate on behalf of EnviroLink, but did not participate on behalf of Currituck Water and Sewer. We're in the process of renegotiating that agreement right now, and I am not participating in those discussions.
Okay, thank you. I just wanted to make sure the record was clear that you did participate on behalf of EnviroLink in those negotiations. The commission, some of the commissioners have some concerns about the stipulation. And so what we're here today to do is we're trying to make a determination about whether we are going to approve the stipulation, and especially the provisions about no penalties being assessed at this time. And can you help the commission understand why penalties should not be assessed? I've heard you state that you were not aware that customers were being billed without CPCNs having been provided, and I think in one of the subdivisions without a CPCN application having even been filed at that time. Help us understand why it's not a blatant disregard on behalf of the company of the law and the commission rules.
Well, certainly it was not, on my part, it was not blatant at all. And I think.
Why would it not be deemed to be blatant, since you're the owner of the company?
Yeah. I think, look at the actions that we've taken since this all came up. If you look at, our discussions and the things that we've offered, to as part of the stipulation with the public staff, what measures we've taken to date, what future measures we've agreed to take, that all of that should be taken into consideration.
And then I heard your testimony about refunds, you're working with public staff to determine the amount of the refunds to go to the customers. Is that correct?
The amount in the calculation, because we agreed to refund those with interest. And so we just wanted to make sure that public staff agreed with our calculations before we issued those refunds.
Okay. And the public staff filed its complaint on, I believe, June the 28th of 2024. Can you help the commission understand why the refunds have not been provided to the customers previously? It's almost 9 months since the complaint was filed. So to the commission, it seems like a lot of time has passed, and why this has not been accomplished until now, or it still hasn't been accomplished, but why has it taken so long?
I mean, I think the reason it hasn't is we've tried to work through these issues with public staff and have wanted to make sure that we had kind of a clear path moving forward before we issued the refunds. We've been prepared to make the refunds, as soon as we can reach agreement with the public staff on what to do and how to do it.
Okay. And again, it's been 9 months. Can you just try to answer the question? Why has it taken 9 months to get this accomplished?
I think, it's just taken 9 months for us to kind of work through all the issues with public staff, as I think my response to it. I mean,
and then I've got just a couple of questions before I turn it over to some of the other commissioners. This deals with the contract between North Carolina Water and Sewer and EnviroLink. What was the date that EnviroLink started providing services for North Carolina Water and Sewer?
Well, certainly, EnviroLink provided what I would call kind of, prior to the system starting to be constructed, provided, review of the engineering plans and those types of things dating back to, I would say, in 2021. The system, I might need to refer to Chuck here in terms of when the system was first commissioned, and we provided, I think it was in October of 22 that the system was commissioned.
Don't remember.
Was commissioned, and we started, providing water service out there.
So we're looking at from 2021 until 2025. Can you help the commission understand why in a period of 4 years there has not been a formalized written contract between the companies?
I don't know that I can offer a good explanation for you, other than the fact that, I was not paying attention at the time, and the staff that I delegated things to didn't get it done.
And I'm going to ask, I want to make sure that one of the portions of the stipulation, one of the things that the public staff was asking for that is not included in the stipulation is an investigation of EnviroLink. So I will ask the public staff when Mr. Hauser testifies about why the stipulation why the parties did not agree to an investigation of EnviroLink. But it does state that the stipulation, I believe on page 10, or excuse me, page 14, and this is paragraph 10, states that North Carolina Water and Sewer will provide access to the public staff of the books and records of EnviroLink. And I want to make sure that North Carolina Water and Sewer and the public staff are completely on the same page about this so that we don't have problems down the road. And I will ask Mr. Hauser as well what his expectation of this is. But what books and records is North Carolina Water and Sewer and EnviroLink going to be providing to the public staff? And I want specificity so that we can ensure that they have what they need to provide audits and determine that payments are fair and reasonable and appropriate.
Yeah, I think any of the accounting records as it relates to North Carolina Water and Sewer certainly would be open to the public staff. Any of our kind of what we call G&A, general administration cost within EnviroLink, are things that we would be open to providing to the public staff. any engineering documents or, construction inspection documents or anything along those lines, certainly would be open to those permits. Those types of records would certainly be open to the public staff.
And what I'm not hearing is any books and records of EnviroLink. Is that correct?
Oh, no, I'm talking about EnviroLink's books and records.
So you will open up all of EnviroLink's and North Carolina Water and Sewer's accounting
Yeah,
and
the
engineering
only,
records.
the only caveat on EnviroLink's books and records would be records related to other clients, not related to North Carolina Water and Sewer.
Okay. And have you opened those books and records up to the public staff yet?
We have not.
Okay. Have they asked for them at this point?
Subject to not part of this proceeding that I'm aware of, but in other proceedings they have.
And in other proceedings, have you provided the books and records to the
We
public
have
staff?
we have provided records. We haven't, can't say that we've provided all of the records that they've requested, but the majority of the records, I believe we have.
And are you anticipating any dispute with the public staff about what you're going to be providing and complying with their requests? Is this an issue that you think that there could be a dispute about down the road?
I don't foresee a dispute.
And then another concern that I have is about the contracts and the process for obtaining regulatory approvals. And on pages 11 and 12 of your direct testimony, and I can wait till you get there if you'd like. And it states that you talk about the process for obtaining regulatory approvals. And I have gone through the docket and reviewed the contracts for Buckhorn Creek and Huffington Manor that North Carolina Water and Sewer filed with the commission. I haven't been able to locate the contract for Norwood Ridge. Has that been filed with the commission?
Can I check and follow
Yeah.
up with you on that?
If it has not been filed with the commission, I'd ask that your counsel file it with the commission, that contract. I was not able to locate it, but if it has not been filed, we would request it be filed
Okay.
in the docket. And then the two contracts that I did review, Buckhorn Creek and Huffington Manor, both Appendix B and Section 4 state that the sale and conveyance of the water system shall become effective only upon the granting of the CPCN by the commission and approval of the water system by DWR. And then Section 13 also states that the closing shall not occur until after the commission has issued the CPCN. So the contracts state that the assets, is very clear that the assets are not to be transferred until after the CPCNs have been granted. So another problem that I'm seeing is that non-compliance even with the contracts. Why were the assets transferred before the CPCNs were granted?
And I'd like to follow up with you on that just to make sure that the assets have been transferred. I believe they have been, but I'd like to verify that before I answer definitively they have been transferred and that the closings have occurred.
Okay, if you could, before you complete your testimony, we'll give you some time to look into that. And then let me just check to see if I have any additional questions. Going back to the lack of a written contract between North Carolina Water and Sewer and EnviroLink, was there a verbal contract between the two companies?
There was.
Okay, I'm sorry?
Yes, ma'am.
And can you describe what that verbal contract entailed with the details as you know them?
So as I know, Mr. Raber would ask, EnviroLink staff, hey, he would ask them to, can you please go provide these types of services. I need somebody to review plans, or I need somebody to start operations of the water system. And so Mr. Raber would give a verbal authorization for EnviroLink to engage in those activities.
And that's the extent of the verbal contract?
Yes, ma'am.
I want to jump in with a couple of follow-up questions before I call on other commissioners. Mr. Myers, what assets does NCWS currently have?
Well, subject to me checking on whether or not we've closed on the 3 water systems that Commissioner Cameron was asking about. It would have the assets of Buckhorn, Norwood, and Huffington. It also has assets, or in terms of it has contracts with other non-regulated utilities to provide services to them in terms of what the contractual arrangements are, what are called concession agreements.
So does it have cash on hand sufficient to make the required refunds under the stipulation?
It does.
And what about to do the system upgrades that are required?
It does.
I mean, I know those dates are still off for quite a few months. What's the reason for the lag time in getting the backup generator and the filtration system?
Yeah, prior to initiating construction, there is a design and permitting requirement on both of those that need to be done with public water supply before those improvements can be started. And so we put enough time in there, hoping to give public water supply enough time to complete their review and us to initiate the construction and finish the construction.
Good, thank you.
Mm-hmm.
Commissioner Hughes.
Thank you. And just looking for some clarification, again, the relationship between the different parties. You had mentioned just a few minutes ago that your involvement had gone back to the design phase. Could you just clarify, is that EnviroLink's involvement or is that North Carolina Water and Sewer involvement?
Certainly, EnviroLink was providing the review of the engineer's designs on behalf of North Carolina Water and Sewer.
And was that done for payment at that time? Did North Carolina Water Sewer hire EnviroLink to do that?
EnviroLink did not receive any compensation for that. No, sir.
So was it the understanding at that time from EnviroLink that they would be the operator once this thing was built? That was a done deal, essentially.
I think certainly that was the expectation. Yes, sir.
I'm not an attorney. I'm not a CPA, and I don't want to go into any business secrets, but from an engineering standpoint, it looks like there's a lot of communication issues between the different entities. And with EnviroLink's capacity here, why not just have EnviroLink buy this? Why have this other group? Because it just seems complicated.
Well, I think, the reason for having it separated is that certainly EnviroLink doesn't own assets and provides operational services. And I think
They don't provide
I'm
operations.
sorry, they do provide operations. Thank you. But I think long-term, in terms of North Carolina Water and Sewer, we would anticipate in the future potentially bringing in, equity partners to allow it to be able to continue to grow and provide services to other communities. And so what the thought putting it in a second company or a separate company gives us the flexibility of bringing in an equity partner on the North Carolina Water and Sewer company without necessarily giving ownership away of EnviroLink.
As far as EnviroLink is concerned, does EnviroLink have clear minimum standards for systems that they will operate when they enter into an agreement? Are there, if you're going to be held responsible, is there a published kind of set of standards that you'll have? And is that what you were going off of when you were kind of making this advice to the developer?
So typically what we do, and typically what we would do is present those to, like in this case, North Carolina Water and Sewer, for them to say they agree with those minimum standards. And then we use those as the basis for comparing against what the engineers are designing.
Okay, and I apologize if those are in the record. Are those in the record anywhere? Those,
Not to my knowledge, but I'm certainly willing to provide those.
well, I'll consult with the presiding whether we ask for that, but for a second, but and then just another distinction. I think EnviroLink, I understand, has a large staff, unlike North Carolina Water and Sewer. Do majority or most of your systems, are they operated by EnviroLink staff, or are there other companies and other parties that are hired to run the systems?
So periodically, EnviroLink will hire, like if there is an issue with locating or finding a certified operator, periodically EnviroLink has hired, I'll call it local certified operators to provide services in certain areas. Currently, we're not doing that anywhere. It's all EnviroLink staff that are currently operating all the facilities.
Okay. Does EnviroLink have any CPCNs for?
It does not.
Would it be in this situation where you had a brand new utility, I guess, North Carolina Water and Sewer, who would be advising North Carolina Water or Sewer on the process for asset ownership and requiring CPCNs and that sort of thing? Would that be, did EnviroLink do that, or did they?
Yeah, largely it would be, EnviroLink or myself.
Okay. But you don't have CPCNs yourself.
Correct.
These minimum standards that you have they been in place from EnviroLink for operation? Have they been in place for a long time?
Several years, yes, sir.
Yes, I mean, since the formation of North Carolina Water and Sewer.
So just so I understand, are these sort of design recommendations, or are these actually EnviroLink? Does EnviroLink have separate standards that says we will not be hired or work for free, depending on the case, for a system that doesn't meet certain standards? Or are you, I mean, not to be tongue in cheek, are you just a gun for hire? It doesn't matter what the system is. If they'll pay you, you'll come.
No, I actually, thanks for the question, and I'm hopefully will answer it, but it may be a little longer winded than you would like. But I know certainly, in the past, EnviroLink has taken on what I would call challenging systems, and been able to find success in kind of bringing those systems up to standards, working with the owners and bringing them up to standards. That actually resulted in part of our business plan on kind of targeting those types of utilities. And, certainly there have been some failures along the way where we were not able to do that for various reasons. It has us certainly, we have decided to kind of rethink how we're doing it. One, EnviroLink has improved its business systems, its due diligence in these areas now, and we're not taking on those types of projects any longer unless, there's a commitment from the owners, in particular on the capital side. And I would say not just a commitment, but some actual demonstration that the capital is there to make the necessary improvements. And so, yeah, certainly the failures that EnviroLink has experienced, I think, contextually, there have been a few of them. I think we're in the range of about 120 or so contracts that we have. And, in terms of the troubled ones are in the range of, I'd say 5 to 10 of those have been troubled in the past. But it does have, certainly when we get the black eye, those get noticed, and it has us rethinking, are we willing to take on those types of projects moving forward? And the answer right now is, we're going to be very selective about the projects that we take on moving forward.
Okay, and so with that, just what the operating the minimum standards, has EnviroLink developed a separate set of kind of operating standards, for lack of a better term, that you won't take on a system that, so that you could provide, or is that still in the process of being worked out, or?
No, so I think what I would say is we beefed up our due diligence, because a lot of these systems are, undercapitalized, historically undercapitalized, haven't had a lot of investment into them. Would we be willing to take on a system that has those types of projects or those types of problems with them? The short answer is no, but unless the owners can demonstrate to us that they are committed to making those types of improvements, the improvements necessary to bring it back up to standards.
Okay. I think that's all for now. Thanks.
Let's go off the record and take a short break. We'll reconvene at 11:20. Two follow-up items quickly. Mr. Myers, Chair Kimmerite was asking you about some information I think you were going to check on to see if it was available.
Thank you. That's actually, I didn't want to interrupt you, but I have answers to one of Commissioner Camerot's questions regarding the Norwood contract. That has been filed under sub 3. And then regarding the closing, we're still checking on the closing.
And Mr. Myers, will you have that information before you step down from your testimony?
Hopefully, but we're waiting on a response from staff.
And if you do not have that information, I would ask for a late filed exhibit.
Yes, ma'am.
Okay,
And
thank
we
you.
will be happy to provide that,
Okay, thank you.
Chair.
And I believe Commissioner Hughes was hoping to get as a late filed exhibit some documentation of your standards related to acquisition of systems. Is that something that could also be provided?
Yeah, one clarifying question maybe for Commissioner Hughes. There was, I think, some discussion amongst ourselves. Were you looking for engineering standards, like construction standards, or were you looking more for like before we would accept somebody as a client?
No, I'm interested in the infrastructure. What kind of systems will you accept?
Okay.
And it sounds like it's a work in progress for Enviroling to have this something comparable to, how challenging does a system have to be for you to not take it? If you have something written, then you could submit that. But if it's just a set of design standards, what size lines, anywhere in between the minimum DEQ standards and something that you're willing to take on.
Certainly construction standards we have readily available that we can file for you.
And Mr. Irvin, you're okay providing that as a late file exhibit?
Absolutely.
Okay, good. Thank you.
And we are continuing to work on the other question as we speak, so. And while I've already interrupted the proceeding, let me ask one further question. If we get an answer from staff, I'm happy to stand up and indicate what the staff told us. Whether that's sufficient for evidentiary purposes, I will leave to you, but that is an option if you're prepared to accept it when we get the response.
Okay, we'll cross that bridge when we get there.
Okay, I'm just offering that
Thank
as
you.
a possibility.
Commissioner McKissick.
Good morning, gentlemen.
Morning.
I have a number of questions for you. And I want to start where Commissioner Hughes kind of ended things, discussing standards. The thing I'm trying to understand is what standards you had at the time that North Carolina Water and Sewer, entered into contracts or agreements to acquire these systems and for Enviroling to manage them. So can you explain what existed at that time that puts us to where we are today in this proceeding?
So North Carolina Water and Sewer has a set of what I would call construction standards that stipulate, line sizes, well house design, minimum amount of water production needed, minimum storage requirements, and those types of standards that would be in place at the time of when we entered into these agreements. Am I answering your question?
Sure. And what type of assessment would have actually been conducted at or about that time where someone would have looked at each of these systems individually, determine how many potential hookups there might be at, say, build out versus how many were actually service connections at that time for people that were using service? I'm trying to understand how we got to a situation where you were acquiring these systems. There were not CPCNs that were out there at the time. And, there was actually a collection of fees and charges from people residing in these particular developments and those funds were being collected. So I'm trying to understand how we got to where we are today to help put some of that in context.
And I'm going to ask a question and see if it's appropriate if I break your question down.
That would be most appropriate. Break it down
Break it down
however
in a couple of aspects for you.
that would be excellent.
Let's see.
It may help put it all in context, perhaps better in framing it than it appears from reading all the testimony.
So, and tell me if I'm on target with this but I'd like to break it down into kind of two processes. One is how does the water system go from, I would say, kind of concept through design, permitting, and commissioning to where it gets in, getting the CPCN versus the mistakes that occurred on the billing side of things.
Sure, feel free to
If that's
break it
okay
down
yeah.
in those subcomponents.
So, and certainly, I'm going to maybe back up because I think, from our perspective, public staff, I think maybe has a perspective and they read the rules. They say, hey, this is the process, and we don't agree that's that they're right in that process. And certainly there was some changes in recent legislation that modified that process a little bit, particularly as it relates to kind of having the pre-filed meeting or a pre-application meeting.
The meeting with the
Yeah.
public staff in
Yeah.
advance of submittal.
Yeah. So, but historically, on a water system, our understanding of how the process was implemented, not necessarily how the regulation says to do it, was that the engineer would design the water system and we would provide them a set of standards with which they needed to design the water system to. We would submit application to public water supply. Public water supply would issue two things. One is called plan approval, and the other one is called an authorization to construct. They would issue those two approvals, and then the construction of the water system could begin. And typically that's once we had the plan approval and the authorization to construct, at that point's when we would file for the CPCN while the system was being constructed. Recently that, public staff has advised us that no, that's not how they want things to proceed. They want the engineer to design it. We get plan approval. Once we have plan approval, we will file for the CPCN. Then public water supply can issue the authorization to construct, and then construction can begin. But
Go ahead.
prior to that,
Do you agree now with that understanding that public staff has articulated in terms of the way the process should work?
yes, sir. We agree that that's
Okay.
certainly that's how that's how it should work. Yeah.
Okay. Go ahead. I didn't mean to interrupt you.
No.
I just want to make sure we were in sync in terms of your position today versus what it would have been from the outset.
Yeah, and we've gone back and done some research on this, and I think back in 2020, the vast majority, at least the ones we reviewed, were processed kind of the way I initially described, and then over kind of since that time to where we are today, the percentage that are following the guidance the public staff has provided is, I think, dramatic. I can't give you 100%, but I think that's the way the public staff would like things to proceed, and we're certainly amenable to making sure that it happens that way. So these systems were constructed, and we typically we rely on the engineer of record to perform the inspections during construction, because he has to certify it at the end of the project. As Mr. Donnell has testified, at least in the case of Buckhorn, there was some construction-related issues related to Buckhorn that resulted in, I would say, electrical issues on Buckhorn that we feel like we've got under control and repaired now and fixed. But agreed to put in a generator to make sure that if there are any further problems that's addressed. In the case of Huffington with the iron and manganese issues, we had guidance from public water supply from them on the use of what's called a sequestering agent versus filtration. And so the decision to allow that to go with sequestering agents out there was largely based on the guidance that was provided and Mr. Donnell was the one that did the review and he can certainly speak to it, but I believe what he'd tell you is he relied on guidance from public water supply in deciding that filtration was not needed up front.
Mhm.
Did I answer your question?
Yes. Now, and as it presently stands, I mean, the sequestration versus the filtration system, where do you stand today in terms of what's going to get done, notwithstanding the fact that there was a difference of opinion previously?
So the stipulation or the settlement agreement
Mhm.
that we have with public staff would require us to put filtration at Huffington.
So that has been resolved fully, completely with the stipulation. And of course, the issue with the generator's going in.
Yes, sir.
All right. Now, I think of you, Mr. Myers, as being a very savvy and sophisticated person. I mean, you've been doing this for 2 decades.
Yes, sir.
So, I mean, I kind of hold you to a standard where well, we assume that you are knowledgeable about the CPCN process, that you're familiar with what Diener is requiring, that you would have exercised due diligence from the outset to have sent someone out to do a report, to have conducted an assessment, to know what the status was of each of these developments that we have North Carolina Water and Sewer, acquiring. And that likewise, EnviroLink would have also been aware of what needed to be done. Is that a reasonable assumption to make?
I think one, I appreciate it, and yes, I would agree, and yes, I take responsibility for it not having been done. And again, I'm not offering this as an excuse, but there was several other things that were pulling me away from being able to focus on North Carolina Water and Sewer back then that had my full attention on those matters. And so I was largely relying on staff to manage things.
And of course, with North Carolina Water and Sewer, you had one staff person.
One staff person and the staff of I would say, also the staff
of EnviroLink, that was what I would say supplementing in many respects.
Yes, sir.
And with them supplementing, wouldn't you say that we should charge them with being aware of all of this as well? And meaning,
I'm sorry.
don't you think we should consider that EnviroLink staff that were involved in working with North Carolina Water and Sewer should have been very much aware of what was going on with these developments and what was going on with the billing and charging of customers?
I think certainly on the construction side, Chuck was very aware and involved in what was going on in terms of, the repairs to the electrical system and assessing it and getting that done. On the billing side, should they have known? Absolutely, they should have known. And I think we've taken appropriate measures to put controls in place to make sure that never happens again. But should they have known? Absolutely.
Would you agree that the fact that they collected the funds, collected the charges from customers is perhaps a very serious and egregious violation?
I agree.
And do you believe that in our position as commissioners, knowing that that was a serious and egregious violation, that it should be perhaps something done other than just going back and refunding the customers those monies with 10% interest?
I think, certainly, I think, and I do think the settlement agreement provides for this, making sure public staff has oversight on our activities and we're keeping public staff informed of everything we're doing. And, as I think meeting with them, I think quarterly is what we've put in the agreement to make sure that we're reviewing and, providing full transparency to public staff is certainly appropriate given the seriousness of the situation.
And as I recall, in your offer of satisfaction, we went back to July 19th of 24. I mean, at that point in time, you were discussing the disgorgement of the funds that you had received and didn't have a problem with the 10% interest compounded monthly. Is there some reason why you didn't proactively at that time go ahead and make those refunds?
As I remember the discussions we were having, we thought it was, kind of prudent to, make sure we were resolving all the issues with public staff and to make sure that everybody was in agreement on this was the appropriate course of action before we made those refunds. So, I mean, we wanted to get to where, we knew that everybody was satisfied with kind of the offer of satisfaction before we did that. But I agree, and it's taken some, I think, to Commissioner Camerate's point, that it's
Yeah.
taken time to get that done.
But I would have thought that knowing what the public staff's position was and knowing that based upon the offer of satisfaction, that was one of the things that you were willing to undertake, that would have been done proactively and expediently as opposed to waiting even until today, March 18th, and no monies have been refunded.
I think what I'd like to do is maybe get together after this and kind of maybe put together a timeline of how that kind of, and for you guys, and we can provide that to the commission to provide further explanation of the timing and what went on.
And I guess as a commissioner, I look at that conduct and look at what knowledge I would impute to you as the owner of these entities and to Envirotech, and say, why shouldn't penalties be assessed as well in this case? Do you have an explanation as to why that should not be an action that this commission might consider being appropriate in light of the circumstances and where we are today?
I think my response to that was certainly understand it's something that you guys are considering, but I would say, in terms of, in response to the things that we've committed to, we've done, to work with the public staff and what we've committed to do and what we have done to date, and looking at the actions that we were doing, up to this point, how we've been proceeding, that should, as I testified before, that should be taken into consideration.
And let me ask a little information now about the documents that public staff has sought in the past relating to Envirotech and, Envirolink, excuse me. I apologize. If I've made that misstatement consistently, then let the record stand corrected. I apologize. That was my misstatement. But to the extent to which those documents have been sought in the past, I think Commissioner Camerite asked some questions about them. Are there any documents that you feel should be withheld at this time and not shared that the public staff has sought in the past?
I can't think of anything that, that the public staff has asked for that we have not provided in this proceeding. Subject to check, and certainly willing to confer with public staff before I make a definitive statement on that.
Sure, sure. And I think we can clear that up with perhaps with Mr. Hauser's testimony, if there's anything out there that they seek that we would want to make certain is being shared. I think you said that all operational information, all the accounting records, at this point in time, anything related to North Carolina Water and Sewer, you're willing to share?
Yes, sir.
Okay. And as it relates to the offer of satisfaction that was made, and as it relates to the stipulation that has been agreed to, is it your understanding at this point in time that the offer of satisfaction is separate and independent, and that the stipulation incorporates all agreements that have been entered into? Or is it your understanding that the offer of satisfaction is a part of what has been agreed to at this time?
I think the offer of my understanding is that the offer of satisfaction is part of the stipulation.
Is part of the stipulation. So all the components that were proposed have been incorporated into it by reference into the stipulation where it stands today.
Subject to check, I believe so. Yes, sir.
Okay. Thank you. I don't have any further questions at this time.
Thank you, Commissioner McKissick. Commissioner Brawley. Commissioner Tucker.
Mr. Chair.
Still good morning to you, gentlemen.
Good morning.
Thank you for being here. I'm one of the folks that called for this hearing so I could get a better understanding of what's going on. First of all, Mr. Myers, North Carolina Water and Sewers owned by Longleaf Utilities LLC.
Yes, sir.
And then that is in turn owned by Two Rivers Holding.
Yes, sir.
And then Two Rivers Holding is in turn owned by the Myers Family Trust, of which you and your wife are the trustees.
Yes, sir.
Why three companies to, I look for why this is done, and it could be watered down for protection, or is it just a normal course of legal action?
Well, that was based on advice of, I would say, advisors and counsels on how to structure that. Is the advice we got and why we did that. Part of the rationale behind that was, given the flexibility to potentially bring in equity partners in the future without necessarily giving up or selling part of the ownership of EnviroLink.
Okay. Just going through some other things, I'm going to be referring initially to docket number W-1334 sub 8 by the public staff. I think you could hear what I'm going to say. I'll read it to you and then you can respond, to that. On page 2, number 4, the public staff says, upon information and belief, Kenneth Raber resides in another state. Is that true?
Yes, he's originally from North Carolina, but moved to Nashville, Tennessee to be closer to family.
Okay, so how can he be president and legitimately run North Carolina Water and Sewer from afar?
Well, he does come over as needed. He'll fly from Nashville to Raleigh anytime that's needed. And he's always available by conference call or video conference.
But does he inspect the property? Does he know what's going on?
When he comes over, he will occasionally inspect properties, but largely he delegates that down to, I would say, where he's reliant on EnviroLink staff to conduct those inspections for him.
Okay, he delegates it to EnviroLink staff. And then in the same number 4 on page 2, it says Michael Myers oversees the day-to-day operations of North Carolina Water Service.
That's
Now,
correct.
how is that correct? You said earlier that you were pulled away from the opportunity to focus on North Carolina Water and Sewer, which we find ourselves in the place today where we are with this. And you have operations, I believe, in my reading, in 5 states.
That's correct.
Okay. How can you assist in the day-to-day operations of North Carolina Water and Sewer? I know we have internet. I know we have iPads, phones, all of that. But I mean, there's a lot going on here in the startup phase and in the situation you find yourself in with violations. You're not running it day to day.
Historically, I was not. I would work with Ken. If Ken had questions or things like that, he would come to me and ask questions. Um, you know, because of what's going on there, I've been forced to get more involved in North Carolina water and sewer and start to take a more active role in North Carolina water and sewer to get the issues addressed and get, begin to rebuild the confidence with public staff and with the commission.
Okay, so your statement is you're forced to be involved day to day.
Well, I think, I won't say forced, but I would say.
That's what you just
prudent,
said.
prudent, for me to get more involved.
Okay. Let's see, on page 3, it says that according to information describing your professional qualifications, that you have over 25 years' experience in design, construction, and management and operation of water and sewer facilities. Is that
Yes, sir.
correct?
Yes, sir.
So help me understand your credential background. Did you work for Diener at one time out of school?
Yeah, back in the 90s, I
Okay.
worked for DEQ.
And you received an undergrad and a master's degree from Ohio State. Is that correct?
Yes, sir.
Okay, and in this document, it talks about with all that background and with all that experience, on page 4 in number 13, Mr. Myers, it says, by the public staff, Mr. Myers is aware of the statutes and commission rules. Is that correct?
Yes, sir.
You are?
Yes, sir.
And then it goes on to state, but has repeatedly chosen not to adhere to them. Is that correct?
I would say that certainly there have been repeated, issues. Was it because of a lack of respect for the commission? No, or lack of respect for the rules? Absolutely not.
So are you admitting today that you realize fully that you violated the law?
As it relates to yes, I think as we've admitted in terms of billing, and we have admitted that we did bill the customers, and that was a violation of statute.
Okay, back to your qualifications, 8 years with Aqua.
Yes, sir.
Okay, and then it stated you got extensive experience, and then it states all the different projects you worked on when you were working for someone else. I mean, I am, as a normal person and not a lawyer, as a new commissioner, I am envious of your background and knowledge in this because it continually comes up, wastewater, independent wastewater treatment plants that are owned by different folks. Let me move on then. Let me try not to repeat what's been asked. Okay. Some of my peers have asked some of the questions. Are you aware that most of the customers, as I have read, in these communities had no real knowledge of North Carolina water and sewer and thought that they were doing business only with EnviroLink?
I've heard that. I think, we tried to make it clear. We issued what was called a letter when each customer connected to the water system. But yeah, we are aware of that and certainly want to make sure that we clarify that moving forward.
What have you done since you became aware of it?
We have held meetings with, in particular, the Buckhorn and Huffington residents, and have certainly tried to clarify that role, the roles of the two different companies, and also address some of the, talk to them about some of the plans for improvements of their water systems.
Okay. Now I'm going to move to your testimony, which you should be familiar with here. I don't want to repeat what someone else has already asked, but I'll try to move forward quickly. There were two applications signed by three applications signed by DEQ or to DEQ from North Carolina Water and Sewer. Two were signed by Mr. Raber, and one was signed by you or he permitted throughout your employment with the company to be able to do that?
Yeah, my role as a manager, I certainly have the authority to sign, and Mr. Raber, as president of North Carolina Water and Sewer, has the authority to
So
sign.
your role is as the vice president, if I understand that correctly. Is that right?
Of North Carolina Water and Sewer, I'm the manager, what's called a manager.
Somewhere I thought I read where you were the VP. Okay. Okay. On page 14, in 5 and 6, as a result of the further conversations with public staff, North Carolina Water and Sewer now understands authorization to construct or evidence of ownership was necessary in order to obtain issuance of a CPCN. And that was contrary to an earlier understanding.
Yes, sir.
Okay, so that would be not your fault, right?
I wouldn't say it was not our fault, but our understanding of how procedurally how that process worked was that you were issued an authorization to construct and plan approval at the same time upon filing, and then we would file the CPCN application after that. And
Okay.
that's, I think, how we, through kind of some of my prior history, that's how we typically would process things.
Okay, so it also states in your testimony, while we would welcome conversation with the public staff and others for the purpose of exploring potential solutions for construction delays created by the process. You didn't know the process, is that what you're saying?
We didn't know the way that public staff wanted the process to work. We've since clarified that process with public staff and understand how they want things to work.
Okay, so humor me, not my fault version number 1 is on, and then now you're welcoming conversation, public staff, that would be not my fault version number 2. Let's move on to page 16, if you would, sir, 15 through 23. In that area, it talked about the EnviroLink employment in approximately January 2024, that Mr. Greer was hired to replace the individual. And is Mr. Greer still with you?
Yes, sir.
Okay. And before you attempted to begin the process of submitting and amending and correctly pursuing the needed CPCNs, public staff had filed a complaint in initiating this proceeding, so they filed a complaint. Is that correct?
I'm sorry, can you?
Repeat it?
Yes, sir.
The question was, why did NCWS fail to immediately begin submitting, amending, or otherwise correctly pursuing applications in these and other cases? That would be on page 16, starting line 12 to 22 of your testimony.
Okay, I'm with you now. I'm sorry to ask you to repeat the question.
Yes, sir. So whose fault was that North Carolina Water and Sewer had not began pursuing the applications until public staff filed the complaint?
I think, as I testified previously, that was the predecessor to Mr. Greer, Mr. Gold.
So again, that would be not your fault, version 3, because an employee had left the company and Mr. Greer didn't follow through.
I would say,
correct?
no, it was my responsibility.
Okay, so it is your fault. Okay, so that's version number 3. How about page 18 in your testimony? Um, on item line number 9, I've come to learn that the same person who did not follow up on various applications filed or needed to file with the commission also allowed the provision of service for compensation to begin without my actual knowledge. So that's, again, you did not know, so that's not your fault, right?
I would say ultimately it's my responsibility. And while I may not have known, it's my it should have been my responsibility to know.
All
Yes, sir.
right, so that's not my fault version 4.0. Okay, and then on page 19, in lines 10 through 15, I'm trying to establish the fact that you can't run a business with your background and your extensive knowledge that you've stated here and what you've been involved in for 25, 30 years, and then say, I regret my responsibility. You broke the law. Straight up broke the law, in my opinion. You just can't do that. Let's go to page 27, lines 14 and 15 of your testimony, sir. It talks here about, I guess, in the community where Mr. Lund presides, which I think is Buckhorn Creek 1, they had low pressure, and it states here that it was due to the developer attending to install sod at multiple properties. Okay, so that was the developer's fault, not your fault. That created the low pressure. What would have kept the pressure up? Was that the area where the generator was going to be installed, is going to be installed, was not installed? Is that the same area?
That's the Buckhorn system is the area where the generator will be installed.
In September.
By September, yes, sir.
Yeah, by September. And the customer was told that they would put a generator in. Then your personnel received information from Duke Power that said the power would be back on the next day. So there was no requirement for a generator at that juncture. And then since then, no generator's been installed because it's going to be installed by September 2025, correct?
I think in that situation, what that's referring to is we have mobile generators that
Correct.
could have been mobilized to the site, and that the decision was made by the operator because of information they received from Duke Energy not to mobilize the generator into.
I'm familiar with that, but
Okay.
from that period, when that decision was made until September of 2025, no mobile generator has been placed there to be operational to avoid the low pressure situation.
Yeah, we're actually not allowed to mobilize the generator or stage it permanently within 100-foot radius of the wellhead.
Because of the plug-in?
No, because they're diesel generators, and we can't have the diesel. Public water supply will not allow diesel to be sited within that 100-foot radius.
Okay, so what kind of generator are you going to put in there in September?
It's gas, not natural gas, LP.
Propane.
So you don't have the same scenario problem with LP versus
No,
diesel?
no, sir.
Okay, in my LP experience, never mind. Okay, let's go to page 29, if you will, sir. Again, Buckhorn 1, we run into a low pressure situation, and it was because, I guess, is this the developer's engineer doing the blow off, or is it your people? That would be, sir, page 29, line number 5. Who was that?
Are you referring to the sentence that starts during the process, however, the engineer?
Yes, sir, the engineer, is that engineer an environment link employee or is that the developer's engineer?
That would be the developer's engineer.
So he began blowing off the system and dropping the pressure in Buckhorn 1 where you've had low pressure issues and there was no notification by North Carolina Water Systems, NC, whatever, North Carolina Water and Sewer to notify those customers?
That's correct, because,
So that's not your fault either, is it? Okay, so that would be not your fault version number 6. Okay, page 32, 7 and 8. Excuse me, 17 and 18 in your testimony.
page 17 and 18.
No, sir, page 32, lines 17 and 18. I'm sorry if I misstated. The generator situation again here that's going in September, you waited again before you installed it to get the best course of action from the community and the public staff. Is that correct?
Yes, sir.
What did you have public meetings at the community and decide that, hey, we can't put diesel in, but we're going to put an LP generator in? Do they know all of this and they know it's coming?
So we did have, I wouldn't say with we had representatives of the community. We had discussions with them about putting in a generator. Told them that we would investigate with, the restrictions regarding being able to put a diesel generator in there, and that we would talk to public water supply and get guidance on them on, what type of backup power we could put in.
I hear you, sir. My question is why didn't you go ahead and put the LP generator in?
We didn't, it was our opinion, we didn't realize that public water supply would even allow LP. The regulation says no contaminants within.
When did you find that out? After you had the low pressure issue in Buckhorn 1?
I'm going to refer to Chuck because he did the investigation.
I talked to the engineers that we actually hired to design the generator, and they said LP would be allowed.
And when did you find that out, sir? After the low pressure scenario took place?
Yeah.
Yes, sir.
And you just didn't want to go to the expense of putting in a generator to eliminate the low pressure complaints? Is that what I'm to assume?
No, I would not assume that. I think what we were trying to understand is what was causing the electrical issues out there, and then making sure that putting a generator out there would solve the problems.
Okay, well, let's go to the electrical issues. Whose issue was the electrical problem? Was that the developer or EnviroLink or North Carolina Water and Sewer?
Well, ultimately, it ends up being North Carolina Water and Sewer's issue to solve. But what caused the faulty electrical work in the well house was the construction that was done by the developer.
Okay, so the electrical issue, was it? So the
Yes, sir.
developer's electrical issue. So again, not my fault, version 7.0. We just keep going here. Then what about the issue with the well house, page 33 on page 10 and 11? The well house has caused issues with the operation of the well pumps turning off. Whose issue's that?
I'm going to refer, because it actually refers to Mr. Donnell will testify in more detail. So I'll ask him to kind of
Yes.
answer.
There are two wells out there. There's a remote well and the well in the well house.
Yes, sir.
One of our standards is we want the wells to operate at the same time. So there's a radio in the well house that communicates with the remote well and tells it to turn on when the well house well turns on. That didn't work correctly, and we had to fix it.
Okay, so it failed one time, you've made the corrections and it's over.
Yeah, a lot of the issues out there we had to diagnose. I mean, it's not immediately obvious when you go out there and something doesn't work, what the problem is.
So the diagnosis process takes how long? And you've corrected it?
Well, you correct something immediately, and then if something else goes wrong later, you have to go out and identify what problem that is.
So when you have these problems, it's a process of elimination.
Yes, well, yes.
Okay. Tell me, if you would, gentlemen, about Mr. Hauser's complaint about the boil water notice. Do either one of you know anything about that? I'll help you
Yeah.
here on
You can
page
help.
34, starting in line 18. On recommendation from DC DEQ, NCWS would typically issue a water advisory if the system pressure dropped below 20. The tank pressure had not dropped below 20, so a system pressure advisory was not issued. What was the system pressure? Do you
We,
recall?
yeah, we monitor the pressure at the tank and, I don't think we know what the pressure was out in the system on that situation.
Okay, so it says here, North Carolina Water Service intends to issue a system pressure advisory of the tank when the pressure drops below 40. Was it below 40 when you monitored it?
It was.
Okay, so why was there not a boil water notice? Because it was between 20 and 40, I'm assuming?
Well, originally, we were going to issue a low pressure notice when the tank dropped below 20. But then we decided that if the system pressure at the tank dropped below 40, that the highest point in the neighborhood would have a pressure lower than 20. So it's, further reflection to decide when to issue those notices.
So your decision was made, even though at the higher levels, it may have been below 20. And correct me if I'm wrong, you certainly are willing, you can correct me, that you didn't do the boil water notice?
That's correct.
Okay, but it was below 20 at the higher levels and above 20 at the lower levels.
It was above 20 at the tank. I don't know what the exact number was,
Okay,
which would make it below 20 at the higher levels.
so Mr. Meyer, since you were involved and have been, and since these complaints have come forward in the day-to-day operations of North Carolina Water and Sewer, why is it that you did not make the decision to do a boil water notice? Is that recommendation from staff? And I'll be glad to let y'all took on that one.
I think, the policy, typically we monitor the pressures at the well house or at the tank. And that's if the pressure there is above the 20, as Chuck, Mr. Donnell, spoke to, we would issue what's called a boil water advisory. And then, in this case, once we realized that, hey, look, the pressure at the higher elevations, if it was at 40, the pressure at the higher elevations would be potentially less than 20. We decided, well, in this situation, we'll issue the boil water advisory when the tank levels drop below.
Since you were there day to day, were you involved in that decision?
I do not recall being part of that discussion.
Okay, all right. I'm just saying that there's been 4 or 5 different low pressure issues here in a row we've talked about. I mean, I don't see all hands on deck to try to resolve them. Generator, no generator, no power, this, that, and the other. But these complaints come in to public staff, and then they have to investigate and do what they need to do. Let me move on. Page 35. You have discolored water, and you made a decision, I guess, to increase the frequency of flushing systems. Is that not a scheduled maintenance that's done? I mean, you know the water's going to get discolored. Why not have a proactive position in flushing before it gets bad?
Well, we do, but typically that's an annual flushing program that we would implement. Once a year, the system would go be flushed. If we get complaints like we did here, oftentimes we will increase the frequency of flushing to be, either weekly, bi-weekly, monthly. And it's, kind of an iterative, as Mr. Donnell was speaking, iterative process. It's, hey, look, how often do we need to flush this thing in order to make sure we're not getting complaints?
So the complaints coming into public staff about discolored water comes from the fact that you're not frequently flushing your systems. Therefore, you would go to a weekly, bi-weekly, quarterly flush system. Have you done so?
We
I
have,
mean, it looks like to me you'd be proactive so you wouldn't have these customers calling, because it creates work for public staff to receive all those calls. Or what is your flushing standard now?
I think right now we're flushing that system
Weekly.
weekly.
Okay, that's pretty proactive to do that. All right, and then talk to me a little bit about on page 35, number 12, the filtration system. Were you involved in that, Mr. Myers?
I was involved in the decision to decide to put in the filtration system.
Has it been put in yet?
No, it has not, but it's currently, we've got the proposal. We're getting ready. Here this week, we'll sign the engineering proposals to start the design and the permitting to put those in.
Okay, so we find out about it in September 2024. We're in March of 25, and we're still designing and determining what a filtration system is.
I think we initially increased flushing and started optimizing chemical additions using a sequestering agent to address those issues, and monitored how that would impact the customer complaints out in Huffington. And then during that time, we entered into discussions with public staff and agreed to put in filtration on those systems.
Okay. I'm gonna just stop there. I have a total of 9 not my fault versions here, sir, that create problems for public staff and your customers. You stated, I think, in your testimony, alluding to what Commissioner McKissick talked about in fines, you asked that public staff not fine North Carolina Water Service because you are a small company. Right. That would be like me going down 85 and speeding and get stopped by the highway patrolman, and I'd say, well, I don't know how I could possibly be running 85 because I've got a small engine. You're in 5 states. My position is you're not going to move with haste and keep the stipulations based on your previous behavior, is my opinion. One quick question for you too. Since Currituck was brought up, you bought the service company from Mr. Freed at Currituck 100%, correct?
Mr. Freed owned a company called Envirotech, which we acquired.
Envirotech?
Envirotech, yes, sir.
Okay, and you're gonna run that system?
I'm sorry?
No, you're not gonna run it. Carolina's gonna take it over as an EO. Let me just flavor me a little bit. What was your relationship with Old State Water Service?
Commissioner Tucker.
Old North State.
Mr. Chair, may I be heard?
Yes.
There is a confidentiality agreement between Old North State and EnviroLink and others that I have, North Carolina Water and Sewer is not a party to that agreement. Because of that, I have not read it personally, but it essentially prohibits Mr. Myers from commenting on the relationship between Old North State and EnviroLink, and I am concerned that in the event that we go into this area, that would put us to the necessity of either complying with that agreement or perhaps violating it. And I would object to that. I don't think we want to go there. I would raise that as a.
I hear that, counsel, and that's fine. I don't need to know anything particular about any of the details. Can I ask the question how long he was involved with Old North State, a period of time in managing that system? That seems to be pretty much above the confidentiality. Everybody would seem to know that.
Yeah, I believe the relationship with Old North State Water Company started in 2012 and ended in the summer of 2020.
Okay, very well, sir. And counsel, thank you. I don't mean to get there. Again, my point is this. Here before me is Old North State. We just went through it. There were many comments made about the previous service that they had received. You lived through it. You know what I'm talking about, and I'm not going to here to expose any confidentiality. But sir, it makes me ill that we have to go to this much effort to resolve an issue in a rate case. And by the way, you perhaps don't know, and I'll share because it's public, we had to go up on those people rates 100% to be able to make that a viable system from a capital investment standpoint and to make sure that they're financially stable to serve roughly in that area about 4,000 customers. And some of those folks mentioned your name in the Onslow County public hearing, the Chatham County public hearing about the continual put off, never getting done, never addressing those kind of statements, which is exactly what I see here, which brings me to the point of saying that you are here asking for forgiveness rather than permission. That's what I see here from my standpoint, having run two businesses in my life. And Mr. Hauser, in his statement, says that based on the evidence and previous behavior of EnviroLink and or North Carolina Water Service, that he does not believe from a public staff standpoint that you will adhere to the stipulations of this agreement. And I hope you prove him wrong, and I hope you prove me wrong. But sir, you've created a lot of work for public staff. You've created a lot of work for this commission. We know of you. We know of your systems. You're a qualified individual. We don't have anything on the agenda other than trying to get to the truth. Public staff has made this settlement, which I don't agree with, but public staff has made this settlement because their job is to look out for the public and to make sure that those customers that you are now serving continue to be served. And hopefully with this settlement agreement, you'll get your act together and that you'll smooth out the waters and that they can be served and public staff will have done their job and you won't have to come back before us. Except if you do not, we also have the authority to not issue CPCNs. And so the onus is on you, Mr. Myers, to clean this up.
100%.
And not vacate or have to vacate the situation like with Old North State. That's my opinion. That's where I see this going. Change my mind, sir. And if you do so, I'll be more than glad to compliment you on your day-to-day efforts of running North Carolina water systems. Thank you, Mr. Chair.
Thank you. Mr. Brawley.
Thank you, sir. I think I'm going to pass on my question.
Well, we have had a robust discussion this morning, so thank you.
We have.
Commissioner McKissick.
Yeah, just one thing for the record. I think there may have been times when I was asking you questions, Mr. Meyer, where I perhaps used the wrong name for the corporate entity, and I was referring to EnviroLink. And I think from time to time, I interjected the wrong entity, EnviroTech. Was it your understanding when I was asking those questions that I was referring to EnviroLink when you responded to my questions?
Yes, sir. My assumption was you were referring to EnviroLink, and I answered the question as if you were asking it as EnviroLink.
Thank you. I just wanted to clarify that for the record.
All right, Mr. Irvin, questions on commission's questions? Oh, I'm supposed to go to the public staff first. Ms. Cox.
I just have just a few questions to follow up on some of the things they asked about Mr. Raber. Who is he an employee of?
Uh, Technically, he's an employee of Longleaf, but he provides, Longleaf being owned by North Carolina Water and Sewer. He provides services to North Carolina Water and Sewer.
And he is their sole employee?
That's correct.
Okay. And then is he the individual that was responsible for charging without commission authorization, or was that Mr. Gold? I heard two names interchanged.
Yeah, Mr. Raber was not responsible for that. That was Mr. Gold.
Okay, thank you. And then just to follow up, the refund calculation that we have been discussing was provided to the public staff for review last Thursday, correct?
Subject to check, I think that's correct, yeah.
And then has a draft of the EnviroLink agreement that includes compensation been provided to the public staff, or is that still in the works at this time?
Apparently, no, I'm mistaken.
Thank you. That's all I have. Thank you.
Mr. Urban.
Right, and counsel for the public staff asked the first question I was going to ask, so we have made progress there. I have a few questions, Mr. Myers, Mr. Donnell. And if you will bear with me, I've got it over several pages of notes, and that may not make for the most organized redirect in the history of commission practice, but I'll do the best I can. First of all, just to get to the principal issue that the Commissioner Tucker was questioning you about. Who is responsible for whatever happens in North Carolina Water and Sewer?
Ultimately, I am.
And is the fact that these things happen something that you personally accept responsibility for?
I do.
What have you done specifically? You've alluded to this somewhat in general terms, but talk to us a little bit about, after having recognized the existence of these problems, what has been done to ensure that there is no repetition and that Commissioner Tucker gets his wish and that problems don't happen in the future?
Well, one, I would say we've invested significantly both in personnel and business systems.
And can you talk to me about what kind of investments in personnel and business systems you have made?
Yeah, specifically, the addition of Mr. Greer is one of the improvements in personnel. We've also brought on another gentleman by the name of Chris Riot, who has extensive experience in both operations and regulated utilities. We've also brought in new managers in terms of some of the operations. We've recently hired a gentleman that we've moved from, has extensive experience in operations, that we've moved from Colorado to here in North Carolina to help oversee operations for us. In terms of the business systems, we've completely redone our accounting system in our accounting department. Now, Mr. Greer spearheaded those initiatives.
You had some questions posed to you, I think, by Commissioner Tucker and perhaps Chair Kimmerer, although I may have mistaken the identity of the questioners, relating to financial impacts upon North Carolina Water and Sewer. The stipulation provides for the installation, as has been discussed, of a generator at Buckhorn Creek and the filtration system at Huffington. Using ordinary rate-making practices as you understand them, and in the absence of the stipulation, what would be the effect on customer rates of the installation of the generator and the filtration system?
Make sure I understand your question.
Would they go up or down?
Mr. Myers, can you speak up a little bit,
Oh.
please?
Oh, sorry. I was asking, clarify your question a little bit.
Clarify, would the effect be to put upward pressure or downward pressure on rates when you install additional capital items of that nature?
There would be an upward pressure on rates.
Does the stipulation deal in any way with the ability of North Carolina Water and Sewer, assuming that it is ultimately certificated and allowed to provide service and charge rates? Does it contain any provisions that relate to cost recovery for the filtration system and the generator?
As I remember, it does.
And what does it do, as you recall?
And we may have to,
Does it allow for full recovery of those costs?
it does not.
Does it allow for recovery of about half of them?
That sounds correct. Yes, sir.
Who gets to bear the other part of those costs?
North Carolina Water and Sewer.
So is there a financial impact upon North Carolina Water and Sewer from this stipulation?
There is.
Do you have any opinion as to the magnitude of it?
The filtration system, I think the estimate or the budgets that we've gotten from the engineer is that will be in the range of $150,000, and the generator, 20,000.
So in the event that the commission was to approve the stipulation, would there be a financial impact upon North Carolina Water and Sewer that it could not recoup from ratepayers?
There would.
You've got a number of questions from a number of members of the commission about the company's original understanding of the certificate process and the process to be followed going forward. Just to be absolutely clear, is the company committed to complying with the process as outlined in Mr. Hauser's testimony going forward?
We are.
Do you intend in any way to dispute the applicability of that set of procedures?
No, sir.
Does the stipulation deal with the issue of clarifying who provides service in the territories that we're talking about in this case?
It does.
And what does it require?
It requires further correspondence between North Carolina and the customers of the communities in terms of clarifying the roles of both North Carolina Water and Sewer and Environlink.
Commissioner McKissick, I believe, asked you a series of questions about the interrelationship between the initial offer of satisfaction and the stipulation. Do you recall those questions?
I do.
Is the request that is being made jointly by the public staff and North Carolina Water and Sewer in this proceeding of the commission that the stipulation be approved?
I'm sorry, can you
Is that what is what's being requested approval of the stipulation that the public staff and the company have entered into?
Yes, sir.
Is that the full agreement between the public staff and the company?
I believe so. Yes, sir.
That's all the questions I have on commission questions. Thank you, Chair Levitt.
If there's nothing further, Mr. Irvin, do you have a motion with respect to your exhibits?
I would move that the exhibits that were attached to the pre-filed testimony of both Mr. Myers and Mr. Donnell be admitted into evidence.
Without objection, so ordered.
And I believe that completes the presentation for the company in this case. To go back to the question that we left hanging a bit ago, we have heard from the staff at North Carolina Water and Sewer, and I'm prepared to give the answer to Commissioner Kimmerett's question if it is acceptable for the commission for me to proceed that way.
Yes, please.
I am advised, and it is from Mr. Raper, that a deed has been executed and recorded for the assets at these three systems. No formal closing occurred, as I understand it, but that a deed transferring them has been recorded and presumably under our race statute is now in effect. So that's the answer that I've been given to your question. I hope it's an adequate one.
Thank you for that.
All right, I think, and we will look into the other issues that we were requested to file exhibits on, and we'll do that in due course.
Well, thank you. If there's nothing further, these witnesses are excused.
Thank you.
Yes. Chair Kimbright.
And I want to interject, there was some discussion about the Old North State order, the rate case order. And I just want to make it clear that we have not yet issued the order and made a final determination about the rates that had been requested, just to clarify the record.
Well, we need to make a decision about whether to proceed. I think it's a close call to public staff. Do you think we have a shot at getting through your case in 30 minutes or so? If not, I'm happy to take a break for lunch.
I think that depends on the number of questions that the commission has for Mr. Hauser.
What's the pleasure of the commission? I've got one vote to keep going. Any objection?
Well, I will agree to keep going if we take a break before starting.
Okay.
And Mr. Chair, for your planning purposes, I have no questions for Mr. Hauser.
Okay. So what do we want to do? Lunch break, 5-minute break? Yeah, okay. We're going to take a 5-minute break and reconvene at 12:36. On the record. Ms. Coxon, anything before we swear the witness?
Yes, the public staff would move the public staff's complaint into the record.
Are you intending to move the response separately?
The response would be North Carolina Water and Sewers. I can move that in if they would like. Whichever.
I had not planned on moving it in. I mean, typically, I don't think of pleadings as being the kind of thing you put in evidence stipulations. A different matter, the CUCA case typically indicates that a stipulation is evidence. But if we're going to put the complaint in, we might as well put the response in too, because there are admissions in those things that clarify the allegations. We admitted some, denied others, and stood mute on others. If they want to put it in, then certainly we probably ought to put the response in as well.
Well, Mr. Urban, I shared your view, but also the second part of your view that if one's going in, I thought perhaps the other should too.
And I agree.
Ms.
Okay.
Coxon, do you mind making that motion?
Sure. I would move that the public staff's complaint be moved into the record.
As well, together with the response.
Together with the response.
Okay. Without objection, so ordered.
No objection.
Okay, we're now ready to proceed.
Mr. Hauser, please state your name,
May,
position.
may I swear the witness first? Find my script here. Mr. Hauser, can you place your left hand on the Bible and raise your right hand? You swear that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may proceed.
Mr. Hauser, please state your name, position, and business address for the record.
My name is Evan Hauser. My position is an engineer with the Public Staff Water, Sewer, Transportation, Telephone Division.
And if you
Alright.
could speak up just a little, Mr. Hauser.
Sorry about, you want me to repeat that? My name is Evan Hauser. I'm an engineer with the Public Staff Water, Sewer, Transportation, and Telephone Division. Our business address is 430 North Salisbury Street, Raleigh.
Thank you. Mr. Hauser, on January 9th, 2025, did you pre-file a public and confidential version of testimony consisting of 49 pages in question and answer format and Appendix A and 5 exhibits?
Yes.
Do you have any changes or corrections to your pre-filed testimony?
No.
If I asked you those same questions today, would your answers be the same?
Yes.
Commissioner Levitas, I move that Mr. Hauser's direct testimony be copied into the record as if given orally from the stand, and that the appendix and exhibits attached to it be identified as marked when filed.
Without objection, the direct pre-filed testimony of Evan Hauser consisting of 49 pages filed on January 9th, 2025 will be copied into the record as if given orally from the stand, and the appendix and 5 exhibits will be marked for identification.
Thank you. Mr. Hauser is available for cross-examination and questions from the commission.
No questions from NCWS.
Okay, well, good morning, Mr. Hauser. I just have a few questions for you. I want to start by just asking you if you could describe in general the public staff's thinking, motivation, approach to its decision to enter into this settlement rather than pursuing prosecution of the complaint.
So our motivation, sorry, let me know if you can't hear me. I want to make sure y'all are able to. Our motivation for entering into a settlement agreement. Is this better? Sorry,
Yeah, that's good.
So our motivation from entering into the settlement agreement is to provide benefits to customers, including service quality, customer service benefits in a timely fashion, as opposed to waiting until there's a, potentially a protracted case involving the CPCN, as well as addressing some of the issues regarding the company's operation without authority.
Good. And specifically with respect to the imposition of penalties, I know you've heard some questions already about concerns about that, given the severity of violations. I think you were present for Mr. Myers' response and the questions from his counsel about some of the expenditures that are being incurred by the company in compliance with the stipulation. Could you just talk a little bit specifically about the decision to forego pursuit of settlements for past actions?
Sure. So we've obviously forgone our pursuit of the sanctions against the company in exchange for getting these customer benefits and limiting cost recovery of them, which will, they'll provide meaningful benefits to customers on their service quality as far as the filtration system in Huffington Manor and the electric generator in Buckhorn Creek. And so we feel that that provides a customer benefit, whereas the sanctions provide less of a customer benefit.
Thank you. I wanted to ask you a little bit about the contract between NCWS and EnviroLink and the investigation of that, or the development of that contract as provided for in the stipulation of settlement. First of all, I think we heard this morning that you do now have a draft contract under review. Is that correct?
We have received a draft contract. My understanding is that the contract, which was discussed to be filed on March 31st, will not be a contract that we have fully reviewed and provided feedback on.
All right. So is it fair to say that your review is really not going to initiate in earnest until you have that March 31st filing?
Yes.
And I'm just wondering if there's anything you want to elaborate on with respect to the issues that you are concerned about, or what you will be looking for in order to make a decision about how to provide feedback on the contract.
On the contract, sure. I believe there was a question from Chair Camwright previously about the investigation. And our understanding is that, or we feel that through item 10 of the stipulation and evaluation of that contract, we'll be able to investigate the company. As far as the specific documents that we would need to review for the contract, I believe that is something that I would have to defer to our accounting and our legal staff, who sort of spearhead our work on reviewing affiliate agreements and agreements of that nature. So I can't tell you specifically, we want to see this, this, and this. But that is something that I'm understanding they intend to do when they get the final filing.
All right. Are you optimistic that you'll be able to reach an agreement with the parties with respect to a contract that satisfies the requirements and expectations of the public staff?
I can't speak to that without having started the investigation. And again, our accounting staff will really have to dig into it. At this time, I'm not aware of us having received a contract that includes compensation in it. That'll be a component as well.
All right. In the stipulation, NCWS agreed to meet with the public staff by the end of February to discuss improvements in communications with customers. Did that meeting occur?
That's correct. We met on, I believe it was Thursday, February 27th.
Yeah. And can you tell us how that went?
Yeah, we discussed a number of items. We were waiting on a few responses. The company was going to look into, for example, specifically with regards to customer service concerns, their phone tree to determine if customers were calling sort of a North Carolina water and sewer number as opposed to an EnviroLink or other utility number that was operated by them. How was the phone answered? My understanding was they were going to look into that. There was some discussion about a new customer letter letting customers know who's the company that owns the system, who's the company that operates it. We additionally had a little bit of discussion about boil water advisory, system pressure advisories, and flushing notices.
And the stipulation also provides for a quarterly meeting to discuss a variety of issues, new customer complaints, and I think the general operation of the systems. Has that meeting, the initial meeting, been held yet?
Yeah, my understanding was the February 27th meeting was for the intention of satisfying
So serve both purposes.
That's my understanding.
And is there any more that you want to share or say about the what occurred in that meeting with respect to that second purpose of considering customer complaints and how to improve overall operations?
I don't think that there was anything substantive at this time, but
Yeah.
I think it'd be necessary to discuss.
Is your general sense that since the filing of the stipulation settlement, that the company has been cooperating with public staff and making progress toward advancing the goals of the stipulation?
With regards to those items, yes, I believe so. The only issue that I'm aware of to date was the monthly complaint report being filed later than
Late.
agreed upon.
Yeah. That's your only concern with the implementation, execution of the stipulation so far to this point?
Yeah, sorry, with their actions to adhere to the agreement until this point, yes,
Yeah.
that's
Okay, thank you. Just one last question from me. I directed this question to Mr. Myers, but I referred to your testimony, page 30, about that's 30 at line 6 through 12, and your suggestion that some of the problems that have been experienced perhaps could have been avoided through more aggressive exercise of rights under warranties in the transfer agreements. Do you want to elaborate on that? That's I don't know if you heard Mr. Myers' answer, but he suggested that that was maybe not the most efficient or productive way to accomplish the ultimate goal. I just wanted to know what you think about that.
so to the extent that the systems that were acquired from the developers already had issues when North Carolina Water received ownership or was deeded the property or whatever. I understand there's a little bit of discussion about what has and hasn't been done. My understanding is that they had items in their contract that they could have utilized the contract language to gain some customer benefit and resolve some of these situations.
Is that a part of the reason that you negotiated to require NCWS to bear some of the cost of making these improvements?
Yes, I would say that would be a contributing factor in having arrived at that item in the stipulation.
Thank you. I have nothing further, Chair Kimright.
I just have a couple of follow-up questions. In regard to the February 27th meeting, you mentioned that one of the things that was discussed would be a new customer letter that would be provided by North Carolina Water and Sewer explaining who the utility was and who the operator of Virelink is. Do you know whether that letter has been provided to customers yet?
We received that letter in email yesterday afternoon, so I hope it hasn't been given out, but I think we would like the opportunity to take a peek at it.
Okay.
But I don't believe so. Or I would hope not.
And then following up on a question that I asked of Mr. Myers about the timing for North Carolina Water and Sewer ceasing billing customers that do not have that, for which the systems do not yet have CPCNs. And my question to Mr. Myers is, did North Carolina Water and Sewer stop billing customers before the public staff contacted North Carolina Water and Sewer and let them know that they were billing customers improperly without CPCNs? And so my question is, do you have an answer to that? Did North Carolina Water and Sewer stop billing before the public staff brought it to its attention or after the public staff brought it to its attention, if you know?
So my understanding is, based on Mr. Meyer's testimony, and the line reference for that is page 17, line 18, that the company stopped billing in April 2024. The Currituck Water and Sewer complaint filed by the public staff was filed on March 26, 2024. So it's possible that the billing stopped after that. But I don't believe that we reached out. Consumer Services may have contacted them, but I don't believe we reached out regarding a provision of services without authority.
For North Carolina Water and Sewer?
Sorry,
Correct.
yes, for North Carolina Water and Sewer.
Okay, let me make sure I understand your question. The complaint was filed for North Carolina Water and Sewer or Currituck Water
Sorry.
and Sewer?
The Currituck Water and Sewer complaint was filed on March 26, 2024.
Okay, addressing similar concerns of North Carolina Water and Sewer. did the complaint for North Carolina for Currituck Water and Sewer, did it involve billing customers without CPCNs?
I have limited understanding of the involvement of the Currituck Water and Sewer complaint, but my understanding is that I do not believe it included discussion about billing North Carolina Water and Sewer customers. Sorry, if I'm making a mess of the two utilities. My understanding is the March complaint for Currituck Water and Sewer did not include anything about billing for customers in North Carolina Water and Sewer service areas.
So the Currituck Water and Sewer complaint was filed first, and then North Carolina Water and Sewer stopped billing customers in the North Carolina Water and Sewer subdivisions. Is that, I just want to make sure that we're clear for the record, is your understanding?
That's my understanding, is that the Currituck complaint was filed the following month. They stopped charging for service according to Mr. Meyer's testimony in April 2024. And then the complaint relating to North Carolina Water and Sewer was filed in June of 2024.
Okay. And for clarity of the record, Mr. Myers is involved in both North Carolina Water and Sewer and Currituck Water and Sewer. Is that your understanding?
That is my understanding.
Okay, thank you. And to be clear from, I want to make sure the record's clear about this too. My understanding from your testimony response to Commissioner Levitis's questions is that the public staff has not yet requested documents or the or to review the books and records of North Carolina Water and Sewer and EnviroLink at this time. Is that correct? Have you made a request to review documents and books and records of North Carolina Water and Sewer and EnviroLink yet?
No, I don't believe we've made that request yet.
Okay. And can you turn to your direct testimony? Because I have some questions. This deals with, this would be on page 46 of your direct testimony. And what I want to try to understand is whether it is the reasons for public staff's initial request to be able to investigate EnviroLink. And in your original complaint and in your testimony, the public staff had recommended that the commission issue an order authorizing it to investigate EnviroLink. And then on page 46, lines 7 through 15 of your testimony, you provide testimony that EnviroLink maintains North Carolina Water and Sewer's books and records, which gives EnviroLink the ability to manipulate North Carolina Water and Sewer's records to mask issues. And so what I'd like to see if you can provide a little bit more context. Are the issues that what are the issues that the public staff believes that EnviroLink might attempt to conceal? Is it related to compensation of Mr. Myers or commingling of funds for operations? What was the public staff's concerns that led it to want to be able to investigate EnviroLink?
I believe those would both be concerned, is how is the money being moved around would be one concern, given the number of utilities operated by EnviroLink, and as well as money received from customers. I believe those would both be things that would be concerning.
Okay. And do you believe that you will have the ability to do your job and investigate for basically the public staff to be able to do its job to for the benefit of the customers once it has the agreement between North Carolina Water and Sewer and EnviroLink and has access to the books and records of both companies? Do you believe that the public staff will have the information to do the proper investigation?
I believe we do, and I also believe that our stipulation has a language regarding automatic penalties, so we do have the ability to sort of hold the company's feet to the fire if they decided that they weren't interested in helping with our investigation or being responsive.
Okay. And the public staff is, along with North Carolina Water and Sewer, requesting that the stipulation be approved by the commission.
Yes.
Okay. Thank you. That's all the questions I have.
Mr. Hughes.
I'm good, no questions.
Commissioner McKissick also passed. Commissioner Brawley. Mr. Tucker.
Heard testimony, heard discussion. On page 43 of the testimony, state that there is little evidence that Sewer would have stopped violating Public Utilities Act and Commission rule had the public staff not had stated that. Then you said that, heard me one, I promise you I want, Bill County Water and Sewer to become more successful and eliminate complaints and serve the customers as easy for the public staff. But you also said that, excuse me, North Carolina Water and Sewer, made a number of good faith efforts in connection with the offer of satisfaction. The public staff is concerned that without commission intervention, North Carolina Water and Sewer, with the passage of time, and the words not will, but with the passage of time, revert back to the behaviors that necessitated the complaint. Based on the first monthly letter being 17 days late, if I recall correctly, is this the type of behavior that you're alluding to? And do you, after going through this stipulation agreement, do you feel that this will be successful for North Carolina Water and Sewer to follow the law, get the CPNs, do the proper apps and the necessary paperwork, and or deal with their customers? That do you think that today still, like you did on page 43?
So we are still concerned about utility, and that's the reason for having included healthy reservation of rights clauses to take the positions that we need to based on our investigations in the various dockets, which will follow from the company, as well as the automatic penalty that if we need it to keep the company in line and following with what they're supposed to be doing according to the agreement.
Okay, no further questions, Mr. Chair.
Mr. Irvin, questions on commission questions? Sorry, Ms. Hawkins.
No questions. Thank you.
Ms. Coxon.
No questions from the public staff.
All right. Ms. Coxon, do you have a motion with respect to your exhibits?
Yes, the public staff moves the exhibits to Mr. Hauser's testimony into the record as pre-marked.
Okay, without objection, so ordered. And Mr. Hauser, you may step down. I think the only other business that we need to address is filing of proposed orders, which I would suggest would be 30 days after delivery of transcript, if that's agreeable.
That's fine with us.
Okay, well, so ordered. And I think we stand adjourned. Thank you very much.
Oh.